So we're just giving people a couple minutes to log on. And then Doug O'Malley will be the first one to speak. He's our state director in Environment New Jersey, and he'll give a quick update. And then Julia Ismailov will give the presentation. Thanks for everybody who keeps getting on. Again, this is Lila Jimenez. I'm the one who emailed most of you. We'll have time at the end for questions, but if you have any that you want to ask during the presentation, use the chat function, or we'll unmute at the end. And yeah, Doug, if you want to start.
Super. Well, Lila, just a big thank you to you for organizing this, and also a big thank you to Julia for the presentation to come. You know, my job here is really you know, not just thank Lila and Julia, but really think of all of you that are on the phone right now, because all of you are really the lifeblood of our organization. All of you are members who've been with us for more than 10 years, which is saying something, because we founded Environment New Jersey in 2006. A lot of you probably know me via the emails. I can promise you I'm more entertaining in person. But I just wanted to give you just a little bit of background on the organization and myself. Talk very briefly just about some of the key campaigns we're working on, and then just give a little bit of color on why I think it's actually really important to think about estate planning, and just about some of my own experiences with it. So just as a background on myself, again, I'm the director of the organization. I started with the organization in 2001 here in Trenton, and then became the director in 2012, which, you know, feels like it's been more like 7 months and not 7 years. Through my work with the organization, and I just got out of a Board of Public Utility meeting here in Trenton, and, you know, oftentimes I find myself in big or small rooms at the State House, and there aren't a lot of, you know, we might have allies, but there's not a lot of people like us. There's not a lot of lobbyists that are actually there to advocate for the public at large, and certainly for the environment. And there honestly aren't a lot of legislators who that's, you know, the first thing that they're thinking about either. And so in many ways, that's why it's just invaluable to have citizen members like all of you on the phone, because we're able to do our work, because, you know, we literally have thousands of citizen members around the state that give us the dollars to be able to lobby with, you know, lobby decision makers, tell the governor to go jump in a lake or to do the right thing. Same thing for the legislature. And those dollars are hard to find. And it's a reason why there are not that many statewide groups in general that lobby for the public interest. And certainly there are not that many statewide groups that focus on the environment. In terms of kind of our top priorities and key issues, you know, we have been working on clean energy and climate issues probably since before I was born. The first day I got into our office in 2001, we had a poster from a conference in Newark that we'd helped to organize in 1979 on solar power. And so I kind of think of our work on climate and clean energy as obviously being multi-generational, but, you know, suddenly, you know, this is not just another issue we're working on. The path to creating a 100% clean energy future is more critical than ever. And also the path to ensuring that we're not continuing to expand on fossil infrastructure is not a threat. You know, we literally have 13 projects around the state, whether you're up in Bergen or down in Cape May, that are directly impacting, you know, our communities and our air quality, our water quality, and obviously the fate of our climate, you know, years and decades hence. So that remains just one of the issues that we've always worked on, but it's just a key issue for us, and one that we spend a lot of time on. Two other issues that we're working on right now. One of the first campaigns that I worked on back in the early 2000s was an effort to get more clean cars here in the state. And starting actually next week, we're doing another set of ride and drives with electric vehicles all around New Jersey. We're working to get more electric cars on the road, more electric buses for New Jersey Transit, and in general, working carbon pollution that's coming from our cars and trucks on the road. And then finally, We're spending a lot of time with the Murphy administration working to expand the protections for our drinking water, streams and rivers and reservoirs. There's a proposal for more than 750 miles of streams and reservoirs that have been proposed. We obviously want to make sure that happens, and we want the administration to go more. And so I think a lot of our work essentially is being a green watchdog and an accountability measure for any administration, whether they're doing good or bad. I know from personal experience that when you have lobbyists in the room that you can see or you can't see, you need someone on the other side. And what we do is obviously not just bringing a voice to lobby for the environment, but working to bring other organizations, other constituencies, whether it be a clean energy company or a labor union or a faith leader, into the room and into the arena. So it's not just the environmental community fighting for an initiative. So that's just a brief update on just some of our kind of top priorities. And I just wanted to spend just a little bit of time talking about my experience with estate planning, which I think for most of us, certainly probably for most of you on the phone, it's not something you think about every day. Certainly, I can testify the fact that, I don't, I have not spent a lot of time in my life thinking about it. But when the moment does strike, you kind of realize that, you shouldn't let it be unresolved. And so I just turned 40 a few days ago. So that's kind of a very exciting milestone. But the first time, I thought, and maybe other of you are in the same camp, the first time I really thought about estate planning was, after my daughter was born, probably, she was about 15 or 16 months. And I kind of realized, look, we were young parents, we still are. We didn't have anything set up, no paper, no napkin, no nothing. And my wife, Katie, and I said, hey, we got to work to get something together. And so we worked to craft a will outlining, what would happen if the unforeseeable happened, if one of us passed away. And then we did this again. My son Malcolm was born about 3 years later. And I can definitely tell you, it's kind of a relief to get it done and actually have all of your T's crossed and I's dotted. As I was going through that process, it also kind of forced me to think about, kind of what's the legacy that I'm not just creating on a daily basis, and all of us are creating legacies with our family, through our work, in our communities, but what's the legacy kind of at the, after we're not here? And so it made me think about the organizations that I wanted to include in my will. And so, I had the kind of the good fortune at the time to be having a conversation with our church. I'm a Presbyterian. And then that also made me think, well, look, I definitely want to include Environment New Jersey in my will. So that, as I was creating it and thinking about my daughter, my son, it just seemed a natural extension to include the organization that I sweat over year in and year out in my will, as well as the house of worship that I attend on a regular basis. So that's just kind of how, when Lila approached me on this topic, it just immediately struck me as something that's not something we usually do, but I think it's just really important as for all of us who care about our families and care about our communities to come up with a plan. And then obviously I'm not, I'm not an estate attorney. And so I'm really grateful to have Julia on the phone and to have Julia to go through, what estate planning actually looks like and what is the best way to do it. And also very excited that Julia is, relatively nearby. I'm sitting here in the State House cafeteria in Trenton. Julia is up at our law firm up in Hackensack. So we're definitely, I'm definitely thankful to each and every one of you for jumping on the phone because of your past support for the organization, and also just thankful that you're kind of willing to kind of think long term, just about what you want your legacy to be. So let me wrap up and just turn it back to Lila.
Oh, thanks so much, Doug. And I know we appreciate you getting on the phone from there. And then I'm just going to turn it over to Julia Ismailov. She's the tax, trust, and estates attorney with Cole Schultz.
Hi, everyone. My name is Juliet Malov, and I work at a law firm, Cole Schatz. We're based in Hackensack, New Jersey, and I do tax trust and estates. And I want to thank Doug for that introduction. He gave a lot of context for this very important organization and for his own experience with estate planning, that he could speak from personal experience about why this is important. And Lila for organizing this presentation. I've enjoyed putting it together with her, so I'll just dive right in. I hope you can all see as I flip the slides. Okay, so we're going to go over the basics of estate planning in a Q&A format that I've sort of designed over the years to address some of the questions people ask, plus some other considerations that people may not have thought about. So the first question that comes up is, do I really need a will? What is this document? It sounds outdated, last will and testament. In this day and age, do you really need it? Everything is, electronic. Everything seems so easily transferable in a way. So the answer is yes. And I know you knew I was going to say that, and the rest of the presentation explains why. So you're either going to, in a way, get organized now and spend substantially less money doing so at this point than later on when your family is potentially scrambling to, first of all, identify all the accounts, all the property you may have owned, and it doesn't have to be a lot. It could be just a number. I mean, all of us go through life and we accumulate certain assets. And the question is, how will they transfer to the next generation? How will you, your financial legacy, how will it pass on to the next generation? Will it be in an organized way, or will there be a little bit of chaos? So the simplest scenario is where someone has a lifelong spouse, they have mutual children, and all accounts are held jointly. If all accounts are held jointly, then theoretically you may not need a will, because by operation of law, the assets will pass to the next generation, or to the joint account holder. So most people's assets are not held that way. So a house could be held jointly with the spouse, but on the second death, as we call it, the property is not going to pass to the children by operation of law. It needs to be deeded, and first someone has to have the authority to deed that property. So I'll just list a number of considerations that go into settling an estate. So there are creditors to be paid, medical bills, funeral expenses, perhaps credit card bills outstanding as of that month or longer, student loans, maybe there is tax debt, maybe it's just for that year, and that goes into the second point of filing a last tax return. As you can see, it's sort of settling your affairs after you're gone. Closing checking accounts and transferring the funds, as I mentioned. Selling a business interest. Maybe you have an operating business. Transferring real property. And also this one is very sort of 21st century, accessing and transferring digital assets. So this is sort of a visual of what I'm talking about. Our life is generally not necessarily always organized in terms of our accounts. We may have opened one account here, one account there. Some people have multiple trusts they've set up over the years. And the idea is to step back and sort of survey what's happened in our busy life and to look at a snapshot in time of what our estate looks like, and then determine how it should work its way to either your spouse, maybe you want to make charitable bequests, even if you are survived by your spouse and your children at that time, or after both of you are gone, you may want to make a charitable bequest or other kinds of specific bequests. And that's the time to create an estate plan. Is more than just to create a will. It's to sit down with all your information before you're, God forbid, someone has become sick or just suddenly passes away. And Doug mentioned, it does give you a peace of mind to go through this exercise, and it's true, a lot of our clients say that to us. So the next question is, doesn't everything just go to my spouse and children? And I touched on that before. The answer is no. If you show a death certificate, even if you're a spouse and you have the marriage certificate, that's not going to work. All these companies have fiduciary obligations to you as their customers, their clients, so they're not going to share information just because someone comes with a document. There's a process, it's called probate. Certain assets pass outside of probate by operation of law, like I said, jointly held assets, but that has to have happened already during life. If an asset is not held jointly, then it becomes a probate asset. It has to go through probate. So what that means is there's a surrogate court that every county has, where when someone dies in that county and they have a will, hopefully, then the family just takes that will to the surrogate court. There's a pretty straightforward process to probate a will in New Jersey, at least. In other states, like Florida and New York, where we also have offices, we find that probate is much more protracted, and so we actually set up something called a pour-over will and irrevocable trust to try to make that process easier by especially if the trust is funded during life. Then at death, it's almost probate becomes sort of nominal exercise, and everything's already in the hands of the trustee nominated. That's outside of the scope of this presentation, but I wanted to raise that for context. And also power of attorney and living will or healthcare directive. Those are documents that you create during your life that provide for those contingencies where you may not have access to your financial accounts because of a physical or mental disability, and you want someone to act in your stead. At the point of death, power of attorney is no longer effective, and the will then is the document that governs and provides that authority to someone else, to maybe the same person or someone else. A living will, healthcare directive, provide also if you are somehow disabled and are not, don't have the capacity to make healthcare decisions for yourself, you will designate someone to do it for you. There are privacy laws related to medical records where even your spouse can't just access them without having that authority under that document. And those laws change all the time, so to have updated power of attorney and living will healthcare directive is important. And also you can express specific, do not resuscitate, those kinds of wishes in that document. It could be as broad or as specific as you'd like. Okay, the next question is, can I just print it on LegalZoom? Your will, that is. So I don't spend a lot of time on LegalZoom, but I did just check out of interest. It says it takes 15 minutes to complete a will. And I know from experience that it takes a good lawyer a few hours at least of combined client discussions and drafting, and then the execution meeting where all the documents get signed. It's a very thorough process. And the reason for that is because we do a fact-specific analysis of your estate. We have an estate planning questionnaire that sets out all your assets. We survey that, and based on our experience, determine sort of what buckets you have your assets in, what potential considerations there are for how the assets should pass, which, and if you're making those dispositions, you are looking at the full pot, not just certain assets, and also making sure that all the assets pass consistent to one cohesive estate plan. So for example, if you are leaving money to your kids in from an IRA, you may be leaving a certain amount. And so if there are other dispositions from your estate, say to a charity or some percentages you'd like to include, you may be doing a disproportional disposition on an overall basis if you're not looking at everything together, if that makes sense. You know, we do have a very large estate planning department here. We're very lucky. It's composed of both the planning administration, which means when a will has to be probated and an estate gets administered, that's a long process, and we have paralegals here who that's all they do all day long, help people with the administration. And then we also have estate litigators. So my point about that is that we look at an estate plan from multiple perspectives. We can identify potential pitfalls, be it a potential will dispute because one of the children is seemingly, influencing the parents to change their will, and we make sure to have those conversations that the parent knows what they're doing, and from an administration perspective, what could be issues? You have a beneficiary designation for 401k. Well, was it completed properly? Is it going to be effective, or are you going to be in a quagmire at the end of the day trying to get the money out? Okay, so this is just one of those examples of people don't think about, they think they have time to complete their estate plan. They put it off. Nobody wants to think about potentially something happens, an accident, and they're not there anymore tomorrow. Do you want your estate to be in sort of the state it's in right now, or do you want to set down on paper what'll happen, especially if people have an operating business that you've worked all your life to build, and it may go to a spouse that has had no prior involvement, and you don't have a succession plan, and what happens with all basically your investments in that business. Maybe your kids are minors and all of a sudden everything goes to them. How is that money, how are you going to protect that money from others and from the children in a way? So these are just some considerations, and I doubt that LegalZoom or sort of doing it on your own, you'll be thinking about everything in the way that we do, and we do have it streamlined at this point, so it's a pretty efficient process. But it's because we have a system, where we do this, professionally. Okay, so another question is, I've already covered it, but some of the other contingencies. This is a big one on the first one on the list. A will that is comprehensive and will achieve your purpose. So, say someone has a disabled child, somebody has a child that they don't even know, but someday maybe there might be creditor issues, IRS issues, maybe a divorce, and Medicaid claims that's more related to somebody's disabled. So how do you make sure that the money that goes to your children, and they may have some issues down the road, so that money is not dissipated on those creditor claims? And the way we do that is a lifetime trust built under the will that makes the child their own trustee, and they can spend the money from that account that's held in trust for health, education, maintenance, and support purposes, which is considered an ascertainable standard, and basically creates a shell around those assets so that third parties and potential creditors cannot reach that money. And I've seen it work. I do some tax controversy work as well, and we had a client who was a beneficiary of a trust that was set up correctly, and he owed a lot of money to the IRS, and the IRS couldn't touch it. So it definitely works, and we do this as a matter of course in our wills, and this is not a tax consideration and it's not incredibly complex, but I would love to see what one of these subscription service wills does for that. And we also keep up with the laws as they change, and as new cases come out where somebody succeeded or didn't succeed based on provisions that were in place, and we adjust our provisions. So we are always updating our documents so that they are as robust and durable as possible. So other considerations like leaving money to a charity, your family may not know what your wishes are in that respect. Also thinking kind of in the shadow of a will contest and making sure For example, we put in a no contest clause, which is supposed to, it's also called interim clause, it's supposed to scare potential beneficiaries under your will from disputing, because then they'll lose that bequest. So then you have to name an executor and a trustee, and you have to put thought into who that might be. Also successors to those people, so you never know who will survive whom, and thinking about those contingencies. Guardians, you've named the couple that you trust, but they divorce. Who is going to take the lead? You don't want them stuck in surrogate court over guardianship of your children. And also, the next one is very important. Are will execution formalities followed? You have to have 2 witnesses and a notary, 3 people in the same room with you. They have to stay there the entire time as you're signing. And then there's an acknowledgement at the end that we put in where the witnesses say that they were there in the room and they believe and they know that you were of sound mind. And so that prevents them having to go into surrogate court to testify, especially in the event of a dispute, that formalities were followed, because we have something called like a self-acknowledgement by those witnesses. And just, 7 times out of 10, if we ever send out a will to be signed with very detailed instructions, it comes back not fully signed properly. For example, a beneficiary under the will might sign as a witness or a notary, and that it creates issues. And then this is also somewhat outside the scope of this presentation, but we do a lot of estate tax planning for those larger estates, and we make sure that whatever exemptions are available are used efficiently during life. Okay, so then I'll move on, and I only have maybe another 5 or so minutes so I'll run through this before questions. What are some other things you may not even think about? So creditor protection was one of those, and I try to emphasize this consideration and these lifetime trusts that we built in. And I already covered that, but even if you have kids who are actually very successful and you don't have to worry about them getting your money, again, somebody else might be after it. Like if you have a doctor who has potential malpractice claims, and business owners may owe just from their business, there could be sales tax issues that creates personal liability. You just never know what might come out of the woodwork, so protecting that money is important. And I covered the other points. And then there is an income tax planning aspect to what we do as well, which is setting up trusts that may be moved to other states that have assets that generate income, and avoiding state tax, which could be up to almost 10%. So it could be a big saving. Also creating liquidity through insurance, making sure that you are as well insured as it makes sense to be, so that money passes to your children for those liquid cash needs, especially if people have, most of their estate is illiquid. Maybe they have real estate investments and the money's tied up. Maybe they have a business that has its own actually cash needs upon death, and you can actually build an insurance through the business on someone's life that it can be sustained and positioned for an exit after death without just being, caught unawares and just having to scramble and sell at a very low price potentially. Okay, and then this is an interesting one, digital assets. We are surrounded by them now, all kinds of information on our computers on accounts held by other custodians like Google and Facebook, and what happens to those accounts, and can your family access them on your death? There are terms of service agreements that specify what happens. And for example, Google has only an authorized representative of the deceased user can access. So it goes back to, does your family member have authority? Are they an appointed executor? There are laws that are being passed in New Jersey and in New York. A statute was passed that says that you can designate a fiduciary. Now, you have to make sure that's done under your documents, and that's both under your state power of attorney during life and in your will. So that's a big consideration. something you have to sit down and think about. Okay, and then leaving a legacy, and I'll end where Doug started. How do you, besides financial assets that you're distributing for the sake of, supporting your family, are you making sort of a statement about your values also during your life and then beyond death? There are different ways to give. One is setting up a foundation, and some people choose to do that. That's a big endeavor and an investment. But most people make charitable gifts to existing charities, like Environment New Jersey. There is a charitable deduction that may be available if the organization has tax-exempt status that could offset income during life and potentially estate tax at death. So during life, gifts can be made just on a one-off basis, writing a check or online. You can also become a regular contributor. I myself support a few organizations that way. I find that it's the easiest way for me to do it. They just charge my credit card every month. And then at death, you can leave a more sizable bequest once the entire estate is established. You know in a way what you're worth and what percentage of that you may want to leave to charity. You can also name, besides doing it through your will, you can name a beneficiary of your life insurance or of an IRA. And you just have to make sure that the beneficiary designation is set up in a way that's, again, consistent with your wishes and consistent with your other documents. And I would just advise to, if you do want a tax deduction, to confirm that the organization is set up in a way that will allow you to take advantage of it. And then the final point is I'm often asked when to update an estate plan, when somebody had already made the effort to set up those documents. And usually you do it when a milestone happens, definitely like Doug was saying, when his kids were born. So when someone gets married, have children, or if somebody dies who you were going to rely on to be your representative. And also you may change your mind or circumstances change through your life of who should receive what and what amounts. And also laws change, federal and state, regarding both tax laws and also administration of an estate or trust that's under your will, like we were saying about the provisions being ironclad, making sure that you're keeping up to date. So, and those privacy laws and from the healthcare perspective. So my rule of thumb is every 3 to 5 years, sit down with your estate planning attorney and just check in and determine if it's time. They'll tell you if it is or isn't. We don't create work. We have plenty of work, so we don't just churn out documents when it's not necessary. We again look at each person's situation, unique situation, and understand and then recommend what works for them. I think that's it, and we'll open it up for questions.
So I think does a will become public after your death?
Will become public after death? Yes, it does become public. And for that reason, some people prefer to set up a revocable trust and a pour over will. And so the pour over will doesn't have the specifics of dispositions and even names. It just goes according to a revocable trust, which is a private document. Any other questions?
Somebody said he wants to say he lost his mother and it would have been incredibly helpful if she had had everything set up. So thank you for providing this information, which I think is a really, like you said, it takes us time, but it makes it easier for people, like you were saying, family members to deal with later. And I will send out an email today or tomorrow too with this presentation, and then also with Julia's contact information. So if you do have additional questions that you're unable to get out today, I'm sure she will be able to respond. And then here's another question from Mohan. Can I keep part of disposition private from some beneficiaries? Example, how much goes to charity?
So a will, it's harder to keep a disposition private because you have to name who the charity is. But if you leave it, like we were saying, under other documents that pass outside of the will, others can't see that. So maybe that's the reason you would leave it as part of your, from your 401k or life insurance beneficiary designation there. That is not public. You could also do it through a trust document, a revocable trust, like we were saying. But I'd be happy to talk to anybody who wants to ask questions after the presentation by just contacting me. You know what? Somebody else asked a question. If you want me to touch, let me just go to the next slide, and that's my contact information. And then we do have a question again from Brenda. Wait a minute. Do you see it?
Yes. What happens if you have no children, no will, and no beneficiaries? Would the assets be up for contention, or do they go to some default location?
Okay, so they may be up for contention if there are if there are heirs who are more distant, if they know about the fact that you passed away and they may be able to bring a claim. There are intestacy laws that determine how assets are distributed in sort of an orderly way. So it goes down, I like to think of it as it goes down your family tree, and then it goes up the family tree. If there's nobody, spouse, no children, it goes up to the children of your parents, so that would be your siblings. And then it goes to their children, and then it can go up even further up the chain to like your cousins and those cousins once removed, twice removed. And again, they have to know that somebody passed away, and there are laws about how long you can bring a claim. It could be a pretty lengthy period of time, and in the meantime, what happens is the state can take custody and become basically a trustee of those assets. But from when I had looked into this question before, they actually don't claim it permanently until years and years later, during which time heirs can present claims, and there are something called heir hunters that take advantage of that. So you have to watch out, who are the real heirs, and the surrogate court will try to sort through that. You have to make certain attestations about, who you are and who you represent in claiming that property. You're welcome. She said thank you. Good question. Thanks for that.
Okay, so I think that's it for the questions now. If you do have additional questions, please let us know. And then just to be sure you guys know that Environment New Jersey, we're not providing financial, tax, or legal advice. Information provided by this webinar does not represent advice provided by or endorsed by Environment New Jersey. Please consult with your professional advisors for information about financial, tax, or legal benefits or consequences of giving to organizations. And we really appreciate you guys taking the time to get on this. And again, if you have any questions, please let us know. Thanks so much.
Thank you.